Hello and welcome to the Herrington Carmichael Employment Law Update for March 2017. I'm Alistair MacArthur, I'm the head of the employment team with Herrington Carmichael. Rather than 4 matters, I've only got 3 for you this month, so let's see what we're going to talk about. First off, the increase to compensation limits from the 6th of April 2017. The government has once again reviewed the compensation limits within an employment tribunal and in relation to statutory payments and have increased these. The headline amount is the increase of the compensatory award for an unfair dismissal claim. That's gone up to £80,541. Added to that is the increase for the calculation of a week's wage. That's gone up from £479 to £489, and that's relevant to all the claims which are capped by a week's wage, such as the unfair dismissal, basic award and statutory redundancy payments. In essence, everything is being raised very slightly. Next, I have 2 cases for you. Firstly, Dawson Daimler versus Taylor Wessing. This case relates to data subject access requests. As many of you know, employees are increasingly making data subject access requests as part of their employment or in relation to litigation or proceedings they intend to make. Under this case, we have a trustee asking to access the file of a solicitor. In the High Court, this case basically had a very restrictive approach to data subject access requests. Whereas by the time the case gets to the Court of Appeal, that's pushed aside. And what we have is we now have a judgment which basically allows a very broad approach to data subject access requests, including the motivation to the data subject access request being irrelevant. So if an employee is making a data subject access request for the purposes of litigation, they're entitled to do that, and you're going to have to disclose your information. The only thing that you're unable to disclose is anything which is covered by legal advice privilege. Moving on. The refusal of holiday in relation to religious festivals. This is the case of Gardew and London Underground. Within this case, Mr. Gardew requested 3 weeks annual leave for the purposes of attending a religious festival. He was denied that and pursued a claim of indirect religion or belief discrimination. What the judgment says is effectively a very strict approach is taken, and it effectively determined that it was family arrangements, not religion or belief, that determined whether Mr. Gardew was wanting to take annual leave. And it also had to be a very genuine request. They didn't believe Mr. Gardew. But what it does demonstrate is it demonstrates the very strict approach that tribunals will take in relation to application of religion or beliefs on an indirect discrimination basis. You've still got to be careful, but it is showing a movement away from a more broad approach and a much more strict approach to when claims of this nature are going to be permitted. That's everything for this month. I hope you have a very good month, and I'll be back in April. Thank you.